Hi, my name is Sarah Benson, and I am the copyright librarian at the University of Illinois Library. Today, we're going to talk about the basics of copyright. First, a disclaimer. Yes, I am a lawyer, but I'm here to provide legal information, not legal advice. If you need the advice of a lawyer, I suggest that you hire one. So, you're all writers, but do you own a copyright? That's a pretty good question. What does copyright cover? And when does it end? And what is a copyright? Well, copyright is a bundle of rights provided to authors, with an end date, of course. If you hear people referring to something in the public domain, that's because the copyright protections have ended and anyone can use that work. What are the requirements to own a copyright? First, you must have some minimal level of creativity. You create something in writing, music, video. Then you must write it down or record it. That's the fixation requirement. And after 1989, that's it. You've got a copyright. The length is rather long, generally the life of the author plus 70 years. Copyright protects writing, choreography, music, visual art, film, architectural works after December 1st, 1990. It doesn't protect ideas. So if I tell you a great idea, but I don't write it down, that's not protected. Nor does it protect facts, or names, titles, slogans, or short phrases, which might be protected under trademark. Data, although there may be some protection for the arrangement and choreography and composition of data. And it doesn't protect useful articles because that's reserved for patent law. What rights do you have as an author? You have the right to reproduce your work and distribute it, such as by selling books. You have the right to create derivative works, such as writing fan fiction. You have the right to perform your work. I'm performing a work right now. You have the right to publicly display your work. And you have the right to license any of the above rights to third parties. License is just a fancy way of saying contract. So who owns the copyright? The author, of course. But who is an author? The author is the person or people who created the work, except when a work is made for hire. If someone hired you to write a work for them, then the employer would own the work. It's also important to note that if there are many authors or joint authors, then the default rule is that each owner has an equal, undivided interest in the entire copyright. Now, otherwise, you can contract around this and decide who actually owns the copyright. Also remember that the author may license or contract their right to a publisher, in which case the publisher would own the copyright for the life of the author plus 70 years. So why should we worry about copyright? Well, you might want to protect your own work from infringement, or you might want to make your work as easy to access as possible, such as open access. Or you may want to legally build on the work of others for research, teaching, art, scholarship, librarianship even. One of the key questions that I get asked frequently is what work is in the public domain? Why would people want to know what work falls in the public domain? Well, work in the public domain can be used for any purpose without permission. You could even print it on a t-shirt and sell it. So it's pretty important to understand what falls into the public domain. Work published in the United States before 1923 is in the public domain. Note the United States part. Work published in the United States between 1923 and 68 may be in the public domain, but we're going to have to come back to this because that time period gets a little bit tricky. So my advice to people when they want to produce work and keep it under copyright is to use the copyright symbol. Although it is currently not legally required, in other words, your work is protected as soon as you produce it, the copyright symbol puts other people on notice. Remember, though, you cannot recover damages for infringement until you've actually filed for copyright with the U.S. Copyright Office. So, even if you put a copyright symbol on your work, you'd actually have to file it with the Copyright Office if you need to enforce that symbol or that copyright protection. You also might want to, in the opposite vein, make your work as easy to access and utilize as possible. So you might choose to put a Creative Commons license on the work if you want to make it open access with limited restrictions. We'll talk about Creative Commons licenses in a bit more detail later. That's the end of my first preview to the basics of copyright.